Greetings, viewers, and welcome to Pitso Podcast. We are meeting once again at Pitso Podcast, where we use our past to make sense of the present, and hopefully shape the future. Today we have a guest who needs no introduction. She's back again, and I would like her to introduce herself. Just greet you. When she greets you, you'll know she needs no introduction. Emma, how are you?
Thank you for having me.
Emma.
Ke bidwa Isabella Mathiba. I'm a lawyer by training.
Emma. You are welcome, man. It's a pleasure to have you once again in such a short space of time. By way of introducing our topic, you remember during the opening of the legal year, Attorney General said or announced that as a Law Revisions Commissioner, he has certain powers to delete certain sections of the law from the law books that have been declared unconstitutional. And true to his word, he has done so recently through Statutory Instrument No. 41 of 2026, where he removed or deleted Section 164 of the Penal Code, subsection A and C. So we'll be talking about that, looking at the powers of the Attorney General, whether he has acted within his powers. So we've invited you here to come and assist us to understand these powers. So I hand over to you, ma'am, for your introductory remarks. What are these powers that the Attorney General talked about?
Maybe before we get to the Attorney Generals or the Commissioners' powers in terms of the Revision of Laws Act.
Yes.
We need to look at legislative powers in general. In terms of Section 86 of the Constitution of Botswana, Parliament has been clothed with legislative powers. But when you look at the Constitution itself and even the Interpretation Act, legislative powers has not been defined.
In simple language, what are legislative powers for?
Yes, the ordinary definition which I had to Google is that it's authority vested in a representative body such as Parliament to create, amend, and repeal laws. It is the cornerstone of democratic separation of powers. Yes.
So legislative power involves those things that you mentioned.
Yes, creating law, amending it, and repealing it.
Yes, you can continue.
With that introduction, we now come to the powers of the Commissioner in terms of the Revision of the Laws Act. Most of them are in Section 9 of the Act.
Yes.
And they cover a vast number of things. I'll pick only a few just to demonstrate what those powers are.
Yes.
For example, we have Section 9M, which talks about correcting grammatical or typographical errors or clerical or printing errors in any written law.
Yes.
And for that purpose, to make verbal additions, omissions, alterations, not affecting the meaning of any law. Not affecting the meaning of any law being the operative words in that provision.
Yes.
And then we also have Section 9S, which is, in my opinion, sweeping powers actually, which says to do all things relating to form or method which to the Commissioner appears necessary for the perfecting of the laws of Botswana. Yes. And then there's also the powers in Section 9A, which talks about consolidating some of them from 12A up to the ones that I didn't mention earlier on, except M and S.
Yes.
It includes consolidating laws that are addressing the same matter. Correction in the order of provision, for example, as they have, this order has deleted section 164A and C. It means there are only 3 subsections in that 164. Or they'll only be left with subsection B. So in terms of this provision, what the commissioner is then empowered to do is to, after deleting A and B, A and C, B then becomes your A. But because it is the only provision there, there will be only one provision in subsection in section 164 of the Penal Code, with no subsection now that A and C have been removed. That is what correction of the order of provisions would mean. And then reordering the table of contents. Every law has got a table of contents showing what is in section 1 up to the very last section. That's reordering. And then amending side notes. In every law you'll find that on the sides there'll be those details indicating what each section is talking about. They can amend those. They can renumber chapters and section numbers, and then delete or spend, extinct, or out of use laws. So those are some of the powers that are in section 9 of the Revision of Laws Act.
I don't want to rush to section 12, which is the one that the commissioner used. Maybe you should make a separation for me, because earlier I used the word Attorney General and you corrected me to say commissioner. When do you use which one relating to the same office or the same person?
The Attorney General.
Attorney General, when do you use commissioner?
The Attorney General is the principal legal advisor to government in terms of Section 51 of the Constitution. The Commissioner is appointed in terms of the Act, the Revision of Laws Act. And in this instance, under Revision of Laws, the Attorney General now wears the hat of the Commissioner. Yes, that is how we separate between the two.
All right. So for this discussion, I should always refer to commissioner.
Yes, for this particular discussion, we are talking to about the commissioner.
Not Attorney General.
Yes.
Getting back to our issue, I want us to define, because the order that I referred to, Order 421, is cited as rectification. So what is this rectification? And earlier on you referred to legislative power. How does it differ, rectification and legislative power? This distinction is very important because it's going to help us determine whether the commissioner was within his powers to do this, or he stepped into a different territory which belongs to Parliament.
Yes. In my earlier definition of legislative powers, I indicated that it is Parliament's power to create, to amend, and to repeal laws. Those powers are clear. They are a lawmaking function. Lawmaking in that they debate bills in Parliament, and once they have been passed into laws, if they need to be corrected or amended, that is a kind of reform of the law. That is when they can reform. And then when those provisions or that particular act is no longer needed, maybe it has been reenacted into a different act, it can now, the old one can now get repealed. It is removed from operation altogether as a law, and it is replaced by something else. Yes, we have recently seen that happen in terms of the different laws that relate to labor laws. There was a repeal of the Employment Act, the Trade Disputes Act, Employers and Trade Unions and Employers Organizations Act in favor of the now Employment and Labor Relations Act. So Parliament repealed all those laws and replaced them with this one consolidated law. So that is what this legislative power is. Now when we take it to the Revision of Laws Act, the power is more or less about a rectification in terms of as we have already indicated earlier on, relating to the powers of the commissioner in terms of Section 9. They are mostly clerical type of corrections without changing the meaning of the law itself. So the moment the meaning of the law itself is changed, then it has now, in my opinion, moved to more like reform than rectification. Okay. The laws, as I indicated earlier on, is about rearranging certain parts of the law, making clerical corrections. For example, I was just looking at this other provision. It was about the Trade Disputes Act, where there was an amendment, and then the order in which the provisions in the main act were referred to differed with what the amendment bill said. So those clerical corrections are then what falls under the rectification powers of the commissioner. Okay. It's more about rectification than reform. Yes. If you can make that difference.
Yes, from if you read Section 9, I think it clearly shows what rectification can refer
different
to.
Types, yes.
Yeah, there are different types of rectifications. Clerical, like where you read 9M.
Yes.
Grammatical, typographical, clerical, printing. Yes, that is rectification.
Yes.
Okay. So in the current situation, the order 41, which rectified or deleted Section 164A and C. We remember the background behind these sections, that a case was settled by the Court of Appeal. So I want to help us understand if a Court of Appeal says something is unconstitutional, whose responsibility is it now to remove the offending sections from our laws? Is it the Parliament or the Commissioner? You remember, even these very same sections were taken to Parliament and were withdrawn. When the Minister then, Honorable Shamukuni, withdrew them, he said it was for consultations. So there are these two processes that I saw happening. Court of Appeal made a decision. Parliament, the law was presented, the bill, and it was withdrawn. So whose terrain is it to fix this that the Court of Appeal has pronounced?
Yes, the case is, let me give the full citation.
Okay.
It's Attorney General versus Letshweletse Motshidimang and others.
Yes.
2023, yes. Botswana Law Reports,
yes.
page 3, CA, which stands for Court of Appeal.
Okay.
It shows it's a Court of Appeal decision.
All right.
And in this ruling, the court used what we call a generous interpretation of the rights to equality, equal protection of the law, and privacy and liberty. I want to zoom in on certain things or certain arguments that were made in this case by the Attorney General in relation to how we are now going to address the question that you have just posed.
All right.
The Attorney General in that case argued that it was Parliament, not the courts, that ought to resolve this issue of decriminalizing Section 164A and C through legislative reform. So it is Parliament's power to decriminalize sodomy through the legislative reform. That was the argument of the Attorney General in this Motshidimang case. And then later, still in what I believe was a buttressing of this very argument that they made before the courts, they then tabled the Penal Code Amendment Bill before Parliament. For Parliament to do its job of legislative reform, amendment, that we talked about when we were discussing the definition earlier on. So based on that, my opinion is that the Attorney General or the commissioner does appreciate that legislative reform belongs with Parliament, not with the commissioner.
You see why it was important to make the distinctions between these two heads.
Yep.
Or when do you say it's Attorney General? You just told us that at the Court of Appeal, the Attorney General representing government said it is the power of Parliament. Now, the Attorney General as Commissioner has done or has gone against what he said in court.
Exactly.
What happens? We are not at section 12, which was used. We will get there. But we just want to understand how these things should have happened. Here is the Attorney General. He went to court and argued that, no, court, you don't have those powers. Yet, Attorney General as Commissioner, now he, on the basis of the judgment, is using those powers as Commissioner to delete Section 164A and C.
Yeah.
So can you help us, if you can, what is happening here?
I will try.
Yes.
Here we have one office wearing two hats.
Yes.
The one of Attorney General and the one of Commissioner.
Yes.
Generally, or in the public service,
Yes.
legal advice is sought from the Attorney General's chambers.
Yes.
So the Attorney General should have advised the Commissioner that this is how we argued, this is how we look at things, and then from that evidence or from that legal advice, the Commissioner should have then acted. So I'm not sure if in this case the Commissioner did not seek the Attorney General's legal advice at all, because had he not, had he done so actually, then this very argument that they made in court should have been brought up to say, as far as we understand it, legislative reform belongs with Parliament.
Yes.
So for decriminalization, although it was declared unconstitutional, the court doesn't have law-making powers.
Yes.
It is once it has been declared unconstitutional, it then calls for the legislative body to go and do the necessary by following due process of repealing or deleting those provisions from the law itself.
Okay.
Yes, that's why earlier on I even referred to the democratic separation of powers.
Yes.
Everybody has got their part to play, and there shouldn't be any overreach between the different arms of government. Okay. In this instance, the Commissioner was acting as part of the executive. Laws in Botswana are not being made by executive decree. They are made through the legislative process through the Parliament.
Okay.
Yeah.
You know, I think you are helping clarify for some of us who don't know this. You know why this case is or this order, Section 164A, that has been deleted by the Commissioner, is very important. It's because a lot of people, especially the Christian community, are against this. They even marched to Parliament. So the feeling among them is that it's like the Commissioner has overstepped. Why isn't Parliament taking up this issue so that them as voters, they know who to deal with? Because the argument is that the Attorney General, who wears the head of the Commissioner, is not elected. So they want to know who is changing this law so that they know how best to deal with them. Yes. That is why we brought this issue here. It's not just we want to understand the revision of the laws. It's because a lot of Batswana are agitated. Now what is happening? It's like people are sneaking laws or changing laws in a wrong forum. So I don't know whether it's a fair assessment by the Christian community to think like that.
Well, I can only give my opinion on the legal aspect of things.
Yes.
But there is some credence to what their concern is.
Yes.
Because, for example, this was the criminalization, the decriminalization of sodomy in Botswana.
Yes.
That's not the first time that it came before the courts.
Yes.
It had been dealt with under another case, State versus Kanani. I think it is a, if I can just go to my...
It also reached
2003. Yes, it was also before the Court of Appeal. The full citation is Kanani versus the State, a 2003 volume 2 BLR, page 64 of the Court of Appeal decision. It had initially come before the Court of Appeal then. And the Court of Appeal said Batswana were not ready to recognize homosexual orientation within the society. The Court of Appeal moved completely from interpreting the provisions of the Constitution which were put before them and relied on some other basis for saying Batswana were not ready to accept homosexuality amongst their society. That it was only in the Motswana case that the Court of Appeal now dealt with the constitutional provisions under which they then declared the section 164 subsection A and C as unconstitutional. So prior to that, UNHCR had made recommendations. I think the first one was in 2008, and then the second one was in 2018. In both instances, Parliament said no. Or rather, let me say the executive then said no. They gave a resounding no. So they couldn't even prepare any amendment bill to bring before Parliament because the executive itself was not convinced of these recommendations to amend the Penal Code in this particular instance. And then there was the August 2023 Penal Code Amendment Bill and the opposition from Christian community against the amendment of the Penal Code in this way.
Yes.
As a result of the oppositional pressure from these religious entities, the bill was deferred to a later date. It was deferred, it was not withdrawn. So as I understand it, deferral doesn't mean withdrawal. It would have, Parliament, I would like to believe as far as Parliament records are concerned, it is something that they are yet to come back to. It's not completely off the books. It is not completely off the order paper, Parliament. As long as it was tabled, it's part of the agenda of Parliament, and it should go back to Parliament. Now we already have an order that has actually done Parliament work.
So I shouldn't use the word withdrawn because
it was deferred.
But the reason was that they are still going to consult. Maybe the change of government could have caused this, or maybe let me put it that way. If a bill is before one parliament and that parliament is dissolved, can it be transferred? I don't know whether you are able to answer that now. Can it be transferred to the parliament that comes after the one that was dissolved?
It's the same parliament, only reconstituted with different members. But Parliament remains the same. So what's on the order paper remains the same until it has been dealt with, either withdrawn or disposed of. Withdrawn, it means it's no longer part of the order paper at all. If it is disposed of, it means Parliament has dealt with it and has done away with whatever needed to be done. So for as long as it's deferred, at least from my interpretation, it remains it remains pending before Parliament.
Okay, I hear you. I hear you. So what you are saying is that there's this pending matter before a body that has legislative power, and another body that has rectification power has acted to remove certain sections of our law before the body that has power to repeal has acted. Is that what you are saying? Do I hear you?
Yes,
to be saying that?
In essence, that is what my opinion is.
So what does that mean? If here is a body, Parliament, they have legislative power which you ably defined for us at creating, amending, and repealing. And another one here is power, according to your assessment, when we read Section 9, is to correct those, not just grammatical, rearrange sections, all those things that you mentioned. It seems like to an untrained mind like mine, it seems like this office of the commissioner is usurping the authority over. That's my assessment. You are here as a legal expert to correct me if I'm wrong. Is that how, or the way that I see it and the way I hear those who are against this commenting, are they in the right track? Are they thinking logically?
Maybe in responding to your question, I should make a reference to this academic article that, when preparing for today's interview, I came across.
Yes.
It's by Fombard and Kwanzaa on the Sabinet African Journal, which in 2007, in their article, they condemned the sweeping powers in Section 12S. So their argument is that a rectification or revision is about simplification of existing laws, and that the words form and method are too wide, and their interpretation are left to whoever is the commissioner at any point in time. So the Section S is such that it is open to such wide interpretation that it is possible for the commissioner to have acted in this instance if they were using their powers in Section 9, subsection S. But in this instance, they have cited Section 12. And my understanding is that although they look or sound the same, Section 12 is actually more limiting than Section 9S when I read them. If I can just refer to your copy there.
Okay.
Section 12 of the Act talks about the commissioner at any time, by order, may rectify any clerical or printing error appearing in the laws of Botswana, or rectify in any manner not inconsistent with the power of revision. You see, it's power of revision, it's not reform. Conferred by this Act, any other error so appearing, or any other matter or omission requiring revision. So it's still talking about revision here. Whereas when you go to subsection S of Section 9, it says to do all things relating to form and method which to the commissioner appear necessary for the perfecting of the laws. Do you now see how the different wording in these two provisions? This one is Section S, is very wide. And because of it, if they had used subsection S,
9S.
at 9S,
Yes.
There might just be an argument that this is an all-encompassing provision, so we were entitled to have acted in this way. But this one, it talks about rectification and clerical or printing errors.
So what we are saying is that using Section 12, which is about printing.
It's about a rectification, rectifying any clerical or printing errors appearing in the laws of Botswana, or rectifying in any manner not inconsistent with the power of the revision conferred by this Act.
Remember, we are discussing Penal Code 164 ANC.
Yeah.
So, which the Court of Appeal has dealt with. So what you are saying is that it's not clerical, it's not printing, as per Section 12.
Yes.
What the commissioner has done does not fall within the scope of
12.
12.
It is possible it could have fallen under 9S. Yeah.
So let's go back to 9S. You're saying it's talking about perfecting. What is this perfecting? Why, from your article that you just cited, you said it's by
Kwanzaa? Fombard and Kwanzaa. I believe these are professors in the University of Botswana, if I'm not mistaken.
Yes, I remember those names from. So, what did they say about perfecting? What is this perfecting? Does it mean, because your argument is that if they had used 9S, they might have a leg to stand on. But now that they've used 12, which is limiting, it will be difficult for them to convince or they've acted within their powers to delete, because it's not clerical, it's not printy. So did the writers of the journal article, did they argue, or what is this perfecting?
Their focus was on the words form and method.
Okay.
They said the words are just way too sweeping or too wide, all-encompassing, catch-all sort of wording, such that anybody can decide how to interpret them and then make use of the all-encompassing language of those words to then do as the commissioner in this case has done. So especially because one of the things that I'm realizing with the draftsmanship in our laws is that a lot of phrases or terms that appear in the laws are hardly defined. So it then leaves a lot of things to each person's own understanding of what certain words or terms in the law means. So that is where then such actions as with this order might then find themselves being inserted where in the ordinary understanding of things, especially when you look at the separation of powers principle. They should not have been done the way that they have been done.
So now here we are in this difficult situation. By my assessment, the commissioner has used Section 12. And like you've just read Section 12, Section 12 says, rectify any clerical or printing error appearing. So now we are here. The court has pronounced. Parliament still has a bill, and then here we have this order 41 of 2026. So how do we get out of this? I know I'm putting you on the spot.
If I may just refer back to your act.
Yes.
But in essence, one of the things that I actually looked at is who has the legal standing. If we were to take this to court and challenge the commissioner's powers. Because
that's where I'm going. Or if somebody goes to court, according to your assessment, or if somebody were to engage you as an attorney, would you say, no, this one I'm going to win, hands down? Yeah, you can continue, but we are going to get there. How do we get out of this? Because you can't have this.
I'm trying to remember the particular provision. I was hoping to remember it off the top of my head because I didn't note it here. But there's a provision in this very act which says, as soon as an order such as this one has been made, it shall be accepted as the law obtaining from the date of commencement of the order.
I remember it too.
So it means as we speak now, since this order has been passed, the law has actually been amended. Unless the contrary is proved. So unless somebody goes to court and say the law was never amended by the proper legislative body, then it means the law has actually been changed, has been amended, in effect.
I want to put it this way. The one and only body that is allowed, that is legislative power. Nobody else has those powers. Has not amended this Penal Code 164A and C. So what you are saying is that if somebody were to go to court, it's challengeable.
Should I even go there? No, I don't want us to go there.
Okay.
I just want to explain that in terms of the law. As soon as this order was published and it has a date of commencement, it means the law has actually been amended. And this very same provision that says it is accepted as the position of the law from the point of commencement of the order. It means it is now law unless the contrary can be proved. So it means somebody has to go to court to say, first and foremost, the Commissioner does not have the power to have amended this bill as they did, because only Parliament, with its legislative powers from Section 86 of the Constitution, have that power to amend this provision. The removal of those provisions from the Penal Code is not a rearrangement. It's not a done deal. The courts do declare provisions unconstitutional to say they don't comply with the Constitution. Whoever has the power to then make sure that the law complies then has to go back and do what needs to be done. In this instance, that means going back to Parliament, which in this case hasn't happened. Somebody else without legislative powers actually did work that Parliament should have done.
According to what you just said earlier on, the bill to delete or repeal 164 is before Parliament.
Yes, it was deferred. It was not withdrawn, and it has not been disposed of because it was never debated. It was never decided whether to maintain those provisions or to delete them.
Okay.
It was up to Cabinet. It was up to Parliament. They might have debated and voted that they are not removing these two provisions, in which case the Penal Code will be saying something else, and we have a court order that says it is unconstitutional. There will be two different provisions in there will be these two things operating at the same time. What would happen is, if somebody is charged with a contravention of Section 164A, what would happen is the court will, once they are dragged before the court, the court will say, this provision has been declared unconstitutional, throw the matter out, until Parliament itself acts to repeal these two provisions. It's not an order per se to Parliament to say, go and remove these provisions. It's just saying, when we look at the Constitution, these rights, or they are not, the Penal Code, Section 164 A and C, they are not in compliance with these rights that are in the Constitution that belong to this smaller group of people. So, yes, there is an existing court order to say this law is unconstitutional. But for it to be brought to be in line with the Constitution, then Parliament has to do its job of removing them. It's not a done deal. Parliament can go debate and decide that no, we are not removing them. They are acting in their representative democratic capacity on behalf of Batswana, a part of whom have already expressed their opposition to them being removed from the statute book of Botswana.
So the commissioner can only act after Parliament said, we agree with you, Court of Appeal. This sections 164A and C.
We agree to abolish them or to repeal them. After which, then, what the Attorney General, the Commissioner then does is to remove them, and then what the subsection B, which has not been touched or affected by this court order, will then become Section 164 with no subsections, because the one on subsection B is it's unnatural acts or having carnal knowledge of an animal, which in the criminal law it's gone in the criminal law areas, we call bestiality. When somebody has carnal knowledge of an animal, the shorter term is bestiality.
Yes.
So we'll only have 164 as a provision that speaks to the offense of bestiality, and then the other subsection A and subsection C will be removed, and that is where now the powers of commissioner come in to rearrange and remove A, so that we are left with only one crime called bestiality in section 164. So do you understand where the powers of the commissioner would have then operated insofar as 164 is concerned?
Yes. So as we discuss this, I think it becomes clear the purpose of this revision of the Laws Act is only after Parliament has made a decision to remove or to keep. That's when the commissioner can come in and rearrange, delete whatever is deleted. If there's a clerical error or a printing error, that he can do.
Yes, if you were supposed to write court and you forgot to put a U, then the commissioner can now correct court to be the correct word.
Yes.
Those are the clerical corrections that this act talks about. Not for the correction to now change the meaning of the act, the law itself. Because by removing subsection A and C, the commissioner has now gone and changed the meaning of the law, because the meaning of the law initially was that these are crimes.
You call it people and animals. If they do this, or if people do this to other people, and
this
do
is an
this
offense.
to animal, it's an offense. Now, by removing this, it's only left when sexual contact is with animals.
Yes.
And that changed the law completely.
Yes, but through Parliament, repealing A and C.
Yeah, that can be done.
Yes, that can be done.
But the commissioner can't do that.
The commissioner does not have the power, at least from my understanding of the powers of the commissioner in Section 9, the entirety of Section 9. I have tried to see whether it fits at M or it fits at S. And in both instances, I didn't find any of those that covers the commissioner's actions insofar as the Penal Code Order 41 of 2026 is concerned. Except, as I indicated earlier on, regarding the challenge that was brought in by Fombad and Kwanzaa, that if in their interpretation, the commissioner was of the belief that form and method covers his doing away with these provisions using his powers, then there might just be an argument that because of my understanding of what form and method means in Section 9S, I was acting in accordance with my understanding of that, especially because form and order or method, form and method has not been defined. Definition is very, very important so that it limits this extended or these sweeping interpretations that this time when Mr. Merrick is the Attorney General, he defines it in this particular way. When next is Mama Mathiba, she then defines it in another way. Some people might be consecutive and define it consecutively. Somebody might not be so conservative and then extend the meaning of the phrase any way they deem fit to suit whatever they need to do.
So if say, I'm just for argument's sake, if say now I realize as the commissioner, I've used the wrong section. I've used Section 12. Now I want to change and go to Section 9S. Is that possible? Is that?
It's possible because if you look at, I think it's 9A.
Yes.
Just as much as Parliament has the power to amend acts of Parliament, the laws, the commissioner has the power to amend his own orders. So this order is what the commissioner has done. So if they want to amend the power with which they used to make this order, they can amend it without necessarily needing to go to Parliament, because they are amending an order, an order, a statutory instrument that is founded from their office. The Section 164C, or the Penal Code as a whole, is founded by Parliament. The order is founded by the Commissioner. Parliament must repeal that which is in the law that it founded. As much as the Commissioner can amend the order that is founded from his office. I don't know if that differentiation is clear.
I get you.
So they can amend it if they want to use the proper provision, or what I believe should be the proper provision, so that it is at least defensible. If they were to argue that they have the necessary power to have done as they did, then they can at least have a leg to stand on.
So if, supposing they had used S, Section 9S, the one that talks about method and form, you say at least they can.
They might just have a leg to stand on.
So if say I'm aggrieved, I'm unhappy about this, and still argue that no, whether you use S or whatever section, this one lies outside your mandate. You don't have powers to make our laws. Can I also have a leg to stand on before court?
You can. Okay. You can, because the thing with interpretation of laws, when you look at the Interpretation Act,
yes,
laws are not read in isolation.
Yes.
You read the law in its entirety in order for you to understand the intention of the legislature in enacting a particular provision. And when you look at this entire act, you can see that the intention of the legislature was never to delegate its power to the commissioner.
Yes.
It never. That was not the intention.
Okay.
When you look at it in its entirety,
okay,
not in isolation, not each section in isolation,
okay,
but in the entirety of the act, you'll see that that was never the intention of the legislature to take its proper representative legislative powers and delegate them to the office of the commissioner.
As the name of the act says, it's the
revision of the laws. Initially, it was called rectification of the laws.
Yes.
Yes. So this is a new term, but bottom line is it means the same thing. So rectification and reform are two separate things.
Yes.
Yes.
Parliament reforms, commissioner rectifies or revises.
Revises, yes.
So I think the other fear that I got from those who are against this is that, there is another case before the High Court of same-sex marriage. The argument of those who don't want this same-sex practices are saying, if it goes to the High Court and the Court of Appeal, it's possible that if the Court of Appeal says stopping somebody from marrying same-sex, it's unconstitutional, then the commissioner would come in and say, I remove. That is their fear.
If this
pattern is not stopped, some were even saying, now it's like, I know you are a lawyer, now they're saying now it's no longer the rule of law, it's the rule of lawyers. Lawyers now are what some say it's the tyranny of lawyers. They're taking over and running our country without parliament. So they are concerned that if this pattern is allowed to continue, all our laws are going to change through this that the commissioner has done.
I can understand that argument.
Yes.
And I appreciate it fully.
Yes.
As we've been discussing, revision or rectification is not the same thing as reform.
Yes.
Or amendment or repeal or creating of laws by the Parliament.
Yes.
So I do understand them, and I believe they do have a point.
Yes.
Yes. If this continues as it has done with this Penal Code revision,
yes,
then I cannot fault their argument.
Yes.
Yes.
Okay. So, phew.
I cannot fault their argument. They have a valid concern.
Yes.
Yes.
Yes. So, just for avoidance of doubt and emphasis, the bill is before Parliament.
It's pending before.
It's pending before Parliament. The Court of Appeal has pronounced. the commissioner has also ordered through Section 12. And if he realizes that, no, I should have used S, he's empowered to change his own order. So we are still in this quagmire, this difficult situation. I want us to emphasize this so that our viewers see the problem, what this order might create.
Yes, as you have already said earlier on, this is a precedent.
Yes.
It's setting a precedent,
yes.
a dangerous precedent at that.
Yes.
So I do legal education, and part of my legal education is what is it now that we have what is it that can happen moving forward so that we don't see a repetition of this? So one of the things that I did is I then tried to find out me who has locus standi, who has the standing to appear before the court and say, I believe the commissioner has overreached into parliamentary territory of lawmaking. Yeah. So
who has that locus standi, as you say it?
The problem with our constitutional design is that we don't have what in other jurisdictions are called oversight bodies that report to Parliament directly. For example, in South Africa, we have the ombudsman, Musireletsi, who, when things of this nature happen, they can make binding or recommendations of what should happen. There would have been the right forum to address this issue. We might even there might even be an opportunity to go to the ombudsman in Botswana.
Okay.
But the problem with the ombudsman's office is that they don't have binding powers as the ombudsman in South Africa.
Okay.
Yes. So for this, if it were to go to court, it needs somebody who has a locus standi, and this means this person must have direct and substantial interest. It must affect them directly. What the commissioner has done must affect them directly and in a substantial way.
So what you are saying is that the Christian community cannot take it to court because
they might not have the necessary locus standi to bring it before the courts.
Well, if the argument is the commissioner has taken powers of our parliament, so you mean as a voter, I don't have that locus standi.
It's standing. Let's just call it standing in plain English.
Yes.
But that is not the end of it. There's also the public interest litigation where we can, whoever takes it to court can argue it on the basis of the constitutional principle of separation of powers.
Yes.
Yes, to say there was an overreach. It affects certain members of the public, and they have a representative organ in Parliament who should go there and debate and decide what should happen with these provisions.
Okay.
Not for the commissioner to have removed these clauses without consulting the proper legislative body that is clothed with the necessary power.
So you are saying that the options that are available is
Public.
The ombudsman, if he had binding powers like in South Africa, or somebody can go in the interest of the public.
Yes.
And say no, there's no separation of powers.
There has been an interference in the powers that is bestowed on Parliament.
Yes.
Yes.
So in the three arms of government, where would the commissioner fit? There's three arms.
The three arms is the executive,
Yes.
is Parliament, is the judiciary.
Yes.
So the courts fall under the judiciary, and then Parliament under the legislature,
Yes.
and then the executive includes the president, vice president, ministers, and the public service.
Yes.
So the commissioner falls under the public service.
So is the executive,
Yes.
which does not have the power to legislate.
Yes.
Yes, it's only Parliament that has. Well, I'm asking this so that we are clear as you say, you do public legal education, so that it's clear that something might be amiss here. Yes. So we are drawing towards a close. Any last words?
In conclusion,
yes.
I'm just going to wrap up everything.
Yes.
Legislative power resides with Parliament.
Yes.
In terms of Section 86 of the Constitution of Botswana, we don't have any defining provision for the phrase legislative power. Its ordinary meaning then applies, which means the power to create, amend, and repeal laws by a democratically elected body. Yes. And then deletion of Section 164 subsection A and C appears to be a usurpation of this repeal power by Parliament. Appears. My opinion.
Yes.
It contradicts the Attorney General's Chamber's own arguments in the Motsidimang case, as well as its subsequent action when it tabled the Penal Code Amendment Bill in 2023. Because if they did not believe, if the Commissioner did not believe that this power resides with Parliament, they wouldn't have even brought the amendment bill before Parliament. They would have proceeded in the manner that they have proceeded now.
I think you are repeating this statement twice. You said it earlier that the Attorney General took the bill to Parliament. Can you clarify that?
Actually,
or they are the ones who drafted it.
The Penal Code in our jurisdiction, what happens is laws are not administered under one body. Each ministry administers different laws. So the Penal Code falls under the Ministry of Justice. So that is why the Minister of Justice and Defense back then took this Penal Code Amendment Bill to Parliament on the instruction of the.
That's why I want to clarify.
The people who are implementing this law is the Directorate of Public Prosecutions, which falls under the administrative supervision of the Attorney General.
Okay.
So the implementing body probably instructed for this amendment bill to be drafted, and it was presented before Parliament by the minister responsible, under which the Attorney General's chambers and DPP falls under.
Now it's clear. Now you can continue with your conclusion.
So it might be argued that Section 12 powers are wide enough to cater for this deletion by the Commissioner, but the Commissioner is also human. He is susceptible to making mistakes, and when that is the case, their mistakes shouldn't be imposed as evidence of the law, especially if the powers are prone to abuse and overreach into parliamentary exclusive power to legislate.
Wow. That's how you concluded.
That is how I concluded.
Thank you very much, Mathiba. We've come to the end of our lovely discussion, eye-opening, educative. Thank you very much once again for availing yourself to come and educate us and members of the public, especially viewers of Pitso Podcast. We have come to the end of our episode. Continue watching Pitso Podcast. Those who have not subscribed, I urge you to subscribe, like, and share with others so that they can also watch and see what is happening in their country. Thank you very much, and see you next time. Thank you.